Hello and welcome to the State and Local Legal Center's Supreme Court Midterm webinar. Happy St. Patrick's Day as well, and happy 27th birthday to me. I am Lisa Sornan with the State and Local Legal Center. Thank you to NACo for hosting this webinar. A few housekeeping matters before we begin. By email, you should have received the speaker's bio and handouts. The handouts will also appear in the chat. To type a question or to ask a question, just type it in the chat box. I will ask the questions to the panelists at the end of the webinar. This webinar is being recorded and it will be made available online on the SLLC's and NACo's webinar. If you're having technical difficulties, please send a message to our organizer via the chat box. The views expressed in this webinar do not necessarily reflect the views of NACo or the SLLC member groups. The State and Local Legal Center has organized this event. For those of you who are new to the SLLC files amicus briefs before the United States Supreme Court on behalf of its members, comprised of the Big Seven national organizations representing the interests of state and local government. These groups and the SLLC's two associate members, the International Municipal Lawyers Association and the Government Finance Officers Association, are listed on this screen. The National Association of Counties is hosting this webinar. NACo's vision is to strengthen America's counties. Its mission is healthy, safe, and vibrant counties across America. I will now introduce our speakers. Michael Dreeben is a partner with O'Melveny. He is writing the SLLC amicus brief in a First Amendment public employment case, which he will discuss in this webinar. Harker Rhodes is a partner with Kirkland and Ellis. He has written the SLLC amicus brief in the Miranda money damages case, which he will discuss in this webinar. Morgan Ratner, Sullivan and Cromwell, is special counsel with Sullivan and Cromwell. Michael, you may now begin.
Thank you. And thank you very much, Lisa, for that kind introduction. And it's a pleasure to be here with you virtually. Maybe next year we'll actually be able to do it in person. I'm going to discuss three cases that involve state and local interests that are before the court. And the first one is, as you can see on the screen, West Virginia versus EPA. This case is a fight over the EPA's effort to reduce greenhouse gases by regulating emissions from power plants under the Clean Air Act. There are huge stakes for climate change and maybe even bigger stakes for administrative law and the balance of power between Congress, courts, and agencies. So a little bit of background on the case. In 2015, the Obama administration promulgated the Clean Power Plan. EPA in that plan relied on a variety of techniques to try to reduce carbon emissions from the nation's power plants, including so-called generation shifting provisions that were designed to move away from coal production to cleaner forms of production like wind and solar. The plan sets forth goals for each state to achieve in reducing emissions and requires the states to come up with their own plans to achieve that. The plan, however, never went into effect because it was instantly challenged by a variety of states, and the Supreme Court in 2016 put the rule on hold. Then entered the Trump administration. It rescinded the plan and substituted the Affordable Clean Energy Rule. For those of you who like acronyms, we'll be talking about the CPP, the Clean Power Plan, and the ACE rule, the Affordable Clean Energy Rule. That rule resulted from the Trump administration's conclusion that the Clean Air Act required that EPA regulate plants and their emissions at the source plant level. That meant that the EPA could require things like smokestacks that would reduce pollution or other pollution reduction techniques at the plant itself, but it couldn't engage in system-wide reform of the nation's entire energy industry. This rule, the ACE rule, was itself challenged by a separate group of states and industry and environmental actors, and the DC Circuit set it aside. it concluded that the Trump administration had adopted too restrictive a concept of what EPA could do, that the statute was not clear on the issue, and therefore you go straight to Chevron deference, which means that the EPA could come up with its own formulation, and maybe it could adopt the ACE approach as a matter of discretion, but it wasn't bound to do that. The EPA said, hey, we're going back to the drawing board anyway. We're going to design a new rule because lo and behold, due to market forces, all of the pollution reduction goals, or at least most of them, had been met even without implementing the Clean Power Plan. Notwithstanding that, the coal industry and several states, including West Virginia, challenged the DC Circuit's ruling in the Supreme Court. And after conferencing the case a number of times, the court agreed to hear it. So we have states, local governments, industry actors at most levels on both sides of this case. 2 coal mining companies in West Virginia, North Dakota, and other states are on one side, and then large power companies and a number of states, blue states led by New York, are on the other side. So before we get to the nitty-gritty of the case, it's important to note that it sets up a major test about a highly contested doctrine in administrative law now called the Major Questions Doctrine. We'll talk a little bit more about the Major Questions Doctrine. The court certainly talked about it at its February 28th oral argument in this case. But before we get to that, it's important at least to talk about what the statute actually says. So the statute in the Clean Air Act allows EPA to regulate the best system of emissions reduction in order to reduce covered pollutants and to come up with plans that states then have to meet. The central interpretive question is whether EPA is limited to measures that have to take place at the physical plant level, or can it go beyond that and treat the system of coal production, power production as a nationwide whole or a statewide whole and seek to implement reductions across the board. And this matters because EPA in the Clean Power Plan had mandated or at least authorized measures, taken into account measures that would involve trading pollution credits from an inefficient plant to a efficient plant. So you get reduction of the same amount of pollutants totally, but you do it by having one plant that's more efficient to trade its pollution credits to other plants. And of course, there are measures in the Clean Power Plan that would encourage shifting to wind and solar, not just making coal production cleaner. So the way that the industry in the states described their rule was it's an inside the fence line rule. EPA is limited to regulating inside the fence line at the plant level. This case also raises a technical but important standing or justiciability issue. The DC Circuit set aside the ACE rule, and the question is, what is left? Did the Clean Power Rule come back into effect, or is EPA back to the drawing board, in which case there's no rule for the court to review at all? The Biden administration says there's nothing here to review. West Virginia says no by setting aside ACE. The CPP automatically came back into effect, and the court will have to decide before it decides the merits whether it really has a case before it at all. All right. Going to the oral argument itself, there was a lot of action on the Major Questions Doctrine. What is that doctrine? Well, that was one of the questions that the court had to resolve. In a few past cases, the court has said that when an agency does something that is, quote, of vast economic and political significance, that doesn't seem to be in line with what it has previously done, Congress needs to make a very clear statement that authorizes the agency to do that. This rule comes from cases like FDA versus Brown and Williamson, where the FDA sought to regulate tobacco, the Alabama Realtors Association from earlier last year, where the CDC had tried to impose an eviction moratorium in order to limit the spread of COVID-19. And most recently, NFIB versus OSHA, where the court put a hold on the employer vaccine rule that OSHA had promulgated in order to achieve reduction of COVID transmissions in the workplace. It's a debated rule, and one of the key questions is, well, does it exist and what does it really do? So going to the actual oral argument, there were a number of justices who seemed intrigued by major questions, but had a little bit of trouble understanding how that correlated with the rule that West Virginia wanted. After all, an inside the fence line rule would not preclude EPA from saying no coal-fired plant may continue to exist. You've got to convert totally. That would stay totally within the fence line, but it wouldn't really answer the question of, was EPA authorized by Congress to revolutionize and totally reform and restructure the entire power industry. Notwithstanding that kind of disconnect between the legal rule that the challengers seem to want and the major questions doctrine, there were a lot of questions about it, some from sympathetic justices, others from hostile justices. They lined up in somewhat predictable patterns for those who've been following the court this term of kind of a 6-3 divide. And the debate about it not only extends to what it means, but how do you identify when it happens? One of the EPA's key arguments was, hey, look, until we have a rule in place, you have no way of knowing whether what we're doing would raise a major question of vast economic and social political significance. And then Justice Breyer came up with one of his classic hypotheticals. He said, no, look, it's like if FDA says, we can regulate the entire tobacco industry. But in this case, we're only regulating 4-foot cigars that are smoked through hookahs. Do you apply the major questions doctrine or wait until EPA actually regulates the entire tobacco industry? The lawyer answered, that's really helpful. And Justice Kagan jumped in to say, it's not every day that a lawyer responds to a Breyer hypothetical. That's a helpful point. So we are waiting on this one. It'll probably go down to the end of the term. And it will, as I said, have very significant effects for both administrative law, possibly for the whole notion of advisory opinions, and certainly for the environment as well. Okay, I'm going to move to a separate case now, one that also involves a dispute between a Biden administration decision and a Trump era rule. So Arizona versus San Francisco was argued before the Supreme Court on February 23rd. And this is one of 3 intervention cases involving state parties on the court's docket this term, for those of you following this area. Cameron versus EMW Women's Surgical Center and Berger versus NAACP of North Carolina also both involve intervention issues. Those cases involve internecine disputes within parties representing states of who really gets to speak for the state interests in the Supreme Court. The Arizona case is quite different. It's a state intervening to defend a Trump-era immigration rule that the Biden administration rescinded and abandoned any defense of. So background here is the public charge rule. Under the public charge rule, implementing a statutory provision, aliens who are likely to become public charges are ineligible for a green card. Now, that had essentially long been interpreted to mean cash aid, but the Trump administration broadened it to include non-cash assistance. This was challenged in multiple courts, and it was struck down by 3 courts of appeals as inconsistent with the statute. The Trump administration sought Supreme Court review. Then the administration changed to the Biden administration, and the Biden administration did not withdraw the petition. And in February 2021, the court granted certiorari. But the Biden administration was not friendly to the public charge rule. Biden had announced that he was not in favor of it. And in March 2021, the Biden administration executed a coordinated strategy to roll back the Trump public charge rule. First, it withdrew the cert petitions seeking to vindicate the rule. Then it dismissed appeals of adverse decisions that had struck the rule down. And on the basis of one district court decision in the Northern District of Illinois that had entered a nationwide injunction against the rule, the Biden administration rescinded the Trump administration's rule. This led Arizona and certain other states to try to intervene in the cases that had been against the federal government only in order to vindicate the Trump administration rule at the expense of what Biden had done to rescind it. The case that's before the court is a somewhat odd case. It's a Ninth Circuit decision that involves a preliminary injunction against the public charge rule. It does not involve actually a permanent injunction or a decision on the merits. And the injunction kind of has no effect now because the Biden administration has rescinded the rule in reliance on that district court decision that I mentioned in the Northern District of Illinois. The question before the court is, should Arizona be permitted to intervene in the Ninth Circuit case, either as of right or as a discretionary permissive matter? And the issue that the court debated at great length is, why does this matter to anything? Justice Kagan finally put her finger on it by saying, what you're really going after is a triple bank shot. First, you want to intervene in the Ninth Circuit just to show that you can vindicate your interests and be permitted to argue in favor of the former public charge rule. Then you want to go into the Seventh Circuit and argue that the nationwide injunction that the district court entered is invalid. And then finally, if you get that set aside, you can go back and file an Administrative Procedure Act case against the Biden administration's rescission of the rule and say, hey, you can't do that because there is no nationwide injunction anymore, so the rule is arbitrary and capricious. There are a lot of pragmatic disputes beneath the surface of this very complicated procedural morass. One is, will the public charge rule cost the states a lot of money? They say yes, it'll cost them $1 billion in additional public aid that they'll have to put out. The Biden administration says the number of people who were disqualified under the Trump rule is like less than 10. So you really don't have anything at stake here. And again, there is a broader administrative law issue lurking behind the surface. And that is, did the Biden administration improperly circumvent notice and comment procedures before rescinding the Trump public charge rule? Remember, what it did is it just said, hey, there's a district court decision that enjoins us. We can't go forward with the rule anyway, so we're going to wipe it off the books. But the hitch here is that that district court decision relies on a nationwide injunction that the Biden administration said to the court is invalid. It doesn't actually have valid legal force because district courts should not be enjoining conduct beyond the scope of their own jurisdiction and the party before it. So nationwide injunctions are very bad. This led to a lot of confusion in the court about what they were doing and what the Biden administration had done. And I cannot even come close to predicting the outcome in this, but I will mention one thing of significance for states and local governments. California was on the other side from Arizona. And California is not hostile to intervention by the states in cases like this. After all, California has done quite a bit of that itself. But California did make the pragmatic point that the Ninth Circuit rule doesn't have any impact on Arizona because it never bound Arizona. It was limited to other states. And in any event, even if Arizona succeeded in getting the Ninth Circuit ruling set aside that upheld the preliminary injunction, it wouldn't do anything because there's still a nationwide injunction in another court that would achieve the exact same effects. So the court has a variety of ways of going on this, broad or narrow. We will have to wait and see where it comes out. Okay, I'm going to shift in my remaining minutes from conflicts between Trump and Biden administration procedural rules to something much closer to home, and that is prayer in a public school. And this case involves an important First Amendment issue that has broad ramifications and significance for the conduct of public employers on a couple of different levels. One issue is the ruling under Garcetti versus Ceballos that public employee speech that's made pursuant to official duties doesn't get any First Amendment protection at all because it's effectively government speech. And then there is a second issue that the court may reach in connection with this case, which involves when public employee private conduct can be deemed to violate the Establishment Clause because a reasonable observer would attribute it to the government and because it might pose a risk of coercing others in the workplace to engage in religious behavior. This case goes back to a dispute that originated in 2015 when a coach, Mr. Kennedy, Joseph Kennedy, believed because of his religious views that he should pray at the 50-yard line after football games in which he was the coach. And over a period of years, he engaged in not only prayer, but also leading morale boosting speeches in which he injected prayer messages and injecting Christian messages into post-game activities in which the students joined along with him. The school board and school district, when it found out about this, asked him to conduct his prayer in a context that would not lead students and the public to be engaged because of concerns about coercion and attribution to the school of endorsing prayer activities. It also invited Joseph Kennedy to engage in accommodations to find other ways in which he could satisfy his religious beliefs and practices without causing the harms that the school district perceived. Mr. Kennedy did not go along with that, and he insisted on continuing his prayer activities. The case bounced up and down to the Supreme Court more than once, and it's currently in the Supreme Court after the Ninth Circuit concluded that Kennedy's prayer was conducted within the course of his official duties and therefore was not protected by the First Amendment. And even if it was viewed as private speech, the school district had a compelling interest that it achieved in a narrowly tailored way to avoid the appearance of an Establishment Clause violation. As Lisa mentioned, State and Local Legal Center, on behalf of a number of organizations, plans to file an amicus brief to explain our view of the reach of the Garcetti rule and to explicate the concerns that are raised by prayer in the context, particularly of a school, but in any workplace environment when there's a danger of both apparent and coercion. And this case will be heard on April 25th in the Supreme Court, and then we will await a decision this term. Thank you, Lisa. I think that covers my cases.
Thank you, Michael. So Harker and Morgan, or Harker, before you start your cases, do either you or Morgan have anything to add to Michael's excellent and thorough description of those interesting cases?
I don't know that I have anything to add. I guess I will just make the one comment that my firm actually represents the petitioner in the Kennedy case, although I'm not personally involved in it in any way. So I'll just add the disclaimer that the views expressed by one member of the panel don't necessarily reflect the views expressed by the firms of the other panelists. But other than that, the other thing that I did think was interesting that Michael's comments raised in my mind was with respect to the Arizona case in particular. just, I think it's one more indication, while it's not directly at issue in this case, of the court wrestling with the difficulties that are caused by nationwide injunctions, and the fact that sort of a single district court under current doctrine appears to be able to enjoin the government from doing anything, anywhere in anything that's at issue in that case, anywhere in the country, which leads to more of these kinds of tangles where, you know, multiple states' interests may be at play based on a single district court decision in a completely different jurisdiction.
And Lisa, I just want to add one thing about Kennedy, which is I think it's going to be a very interesting argument and decision because in the current political context that we're in, there are sort of free speech Garcetti type questions that are coming from both sides, right? There have been a lot of state laws, as most people are aware, that are and local decisions talking about things like maybe on the one hand, restricting discussions of sexual orientation by teachers. On the other hand, in some states and localities having particular rules about transgender students' preferred pronouns. And so you have free speech type Garcetti type claims being raised by teachers who you might have thought, you know, have traditional more right or traditional more left positions. So I always think it's going to lead to a more interesting result where in my mind, that case doesn't necessarily have a clear political valence to it.
Excellent point. So with that, Harker, you may start on your cases.
Thanks very much, Lisa, and thanks as well to the SLLC and to the National Association of Counties for having me on for this panel. So I'll actually be talking about 5 cases today, but they kind of fall neatly into 3 buckets. The first 2 cases that I'll be talking about are Rivas Villegas versus Cortes Luna and City of Tahlequah versus Bond. These are 2 cases that were actually decided already earlier this term and that were decided in summary reversals, which mean that the Supreme Court didn't hear oral argument or have merits briefs for these cases. It just looked at the certiorari stage briefs and said, based on the briefing that we got when you were asking us to decide whether to take this case, we already know what the right answer is, and we can just go ahead and reverse right away just based on looking at the decision below and the petition and the response to the petition and reply. So the court tends to reserve that for cases where it thinks that the decision below is just obviously wrong, and so it's not worth the court's time to kind of go through all of the briefing and oral argument that they would otherwise hear in a full merits case. And it winds up being particularly common in a few areas. There's a few places where the court kind of likes to do these summary reversals because it thinks that the courts of appeals are just interpreting some particular doctrine in the wrong way. And in particular, these cases arose in the context of the qualified immunity doctrine, which says that when a person is suing a state official for violating his or her constitutional rights, that the state official can only be held liable if what the state official did was clearly a violation of federal law. In other words, the right that was violated was clearly established, and no reasonable official could have thought that what the state official was doing was in fact in compliance with federal law. In these particular 2 cases, these both arise out of interactions between the public and police officers. So in the Rivas Villegas case, you had a 12-year-old girl who calls 911 and says, my mom and my 15-year-old sister and I are all hiding locked in a room in our house, and my mom's boyfriend is after us with a chainsaw, please send help. And so 4 police officers arrived on the scene, and they encountered a man who appeared to have a knife in his pocket. They told the man to put his hands up. He did, but then began lowering them. The officers shot him twice with beanbags, and then the man sort of raised his hands up in the air again, and they told him to get down on the ground. He got down on the ground, and a police officer, Rivas Villegas, put his knee on the man, Cortes Luna's, back and held it there for about 8 seconds while the man was being handcuffed. And the man sued, saying that the police officer had used excessive force by putting his knee on Cortes Luna's back for those 8 seconds. In the second case, the City of Tahlequah versus Bond case, you have a woman who calls the police saying that her ex-husband is drunk in her garage and that he wouldn't leave. The police respond, they find the man in the garage, they're talking with him, the police come into the garage to talk to him. The man backs up to a rack of tools, picks up a hammer, turns back towards the police. The police yell at him to stop. He doesn't stop. He lifts the hammer over his head as if he's about to throw it. And the police shoot him and unfortunately kill him. His executor then sues the police, alleging that they used excessive force in their encounter. In both cases, the district court holds for the police officers, says that they're protected by qualified immunity because a reasonable officer in their position wouldn't have known that what they did, that the force that they used was excessive. In both cases, the Court of Appeals reverses, so the Ninth Circuit in the Rivas-Villegas case and the 10th Circuit in the Takeout case, reverse and hold that the officers are not entitled to qualified immunity, saying that based on their own Court of Appeals precedents, that the law was clearly established and showed that the officers' uses of force were excessive. And then in both of these cases, the Supreme Court essentially says, come on, like, even if we assume that the Court of Appeals precedent here is sufficient to show that the law was clearly established in these areas, that the cases that the Courts of Appeals pointed to involved facts that were so different that the officers here could not have reasonably known that what they were doing was clearly unconstitutional, that the Constitution clearly prohibited the level of force that they used in the situations that they encountered. So both of those opinions were issued on the same day in October. There were no noted dissents in either case, so no justice wrote any separate opinion to suggest that that the court was getting it wrong, to both per curiam opinions for the whole court. And so I think these cases are interesting for a couple of reasons. One is that, again, both cases were per curiam opinions with no dissents, which suggests that, you know, despite the sort of discomfort that's been expressed in some quarters with the qualified immunity doctrine, that at least here, the justices intend to keep applying it, you know, unless and until they reconsider it more fully. Interestingly, Justice Thomas has twice written opinions suggesting that the court should look more closely at qualified immunity. But again, at least as long as the court continues to apply the standards that it has, he seems to be willing to continue signing on to these kinds of summary reversals rather than forcing the court to dig into it in more detail. The other thing that I think that's interesting here is, again, it continues the court's practice of reversing summarily in these kinds of qualified immunity cases where it thinks that the courts of appeals have gone way outside their usual or the correct boundaries of the law on qualified immunity. But noticeably, I think it's worth mentioning that in both of these cases, there was actual video recording of the police encounters. In the Rivas-Villegas case from a home security camera, and in the city of Takeout case from a police officer's body camera. And, you know, I think it is interesting that you have sort of that kind of objective evidence of exactly what happened in the video recording, which I think may have given the court somewhat more comfort in reaching their conclusion that, you know, the Court of Appeals was just kind of obviously wrong here and that there wasn't a need for a more detailed briefing because those videos helped more clearly establish exactly what the facts really were. Moving on to the next case that I'll be discussing, it's the Vega versus Takeout case in which the SLLC has filed a brief. Also a case that involves police officers, and also a case that involves a Section 1983 suit against a police officer, but a little bit different, not focused on the qualified immunity questions. The question that's presented here is whether a plaintiff can bring a Section 1983 suit against an officer based on the police officer's failure to provide Miranda warnings before questioning that person when that person's statement is later introduced in a criminal trial against them. So to step back a little bit and sort of give the legal background here, the Fifth Amendment self-incrimination clause says that no person will be compelled to bear witness against himself in a criminal trial. You can't be forced to testify against yourself in a criminal trial. And so to protect that right, the Supreme Court in 1966 held in the Miranda case that as a prophylactic rule, the government would not be permitted to introduce in its case in chief any statements that were made by a person during a custodial interrogation unless that person had first been informed of his Miranda warnings, namely that he had the right to remain silent, that anything he said could be used against him in court, that he had the right to an attorney, and that if he could not afford an attorney, one would be provided for him. Now, in a later case called Dickerson, the court clarified that Miranda was in fact a constitutional rule. It wasn't just a rule that Congress could change through ordinary legislation. At the same time, both before and after Dickerson, the court has also emphasized that Miranda is a prophylactic rule. In other words, it reaches beyond the core of the Fifth Amendment right, and it exists to protect that core right, but it also excludes some testimony that the Fifth Amendment sort of by itself wouldn't exclude. So for instance, because the Fifth Amendment only excludes compelled testimony, the Fifth Amendment itself doesn't say that a person who gives a voluntary statement, that statement has to be excluded. But Miranda does provide for the exclusion of voluntary statements if those statements weren't preceded by the Miranda warnings, and the idea being that that bright line Miranda rule just ensures that the core Fifth Amendment right is protected. So that takes us to the question that's presented in Vega. Under Section 1983, a plaintiff can bring suit against a state official who deprives, or any person who deprives the plaintiff of a right, privilege, or immunity that's secured by the Constitution or by federal law. And so what the plaintiff in the Vega case says is, I was questioned by a police officer. That statement was later, the statement that I gave was later used against me in a criminal trial. I wasn't given my Miranda warnings when I was questioned, and so I'm going to sue the police officer because his actions in interrogating me without giving me my Miranda warnings led to the violation of my constitutional rights when the statement was introduced at my criminal trial. Notably, by the way, the Supreme Court has made clear that if the statement that the person makes is never actually introduced at a criminal trial, then the person clearly can't bring suit because there's no underlying Fifth Amendment violation or Miranda violation if the statement that the person makes is never actually introduced at a criminal trial. Both of those, both the Fifth Amendment right and the Miranda rule, are ultimately focused on what gets introduced in the criminal trial. And so the Ninth Circuit here actually agreed with the plaintiff and said, you know, Miranda, we know it's a constitutional rule based on Dickerson, and the police officer is sort of the motive force behind that constitutional violation because he's the one that takes the statement in the first instance, and he's the one that fails to provide the Miranda warnings. And so you can go ahead and sue the police officer who asks you questions without giving you the Miranda warnings first. The Supreme Court grants certiorari, and the petitioners at this point have filed their brief at the end of February in this case. And the petitioner's brief makes sort of the arguments that you would expect from the discussion that we've had so far. Namely, they say, first of all, Miranda is a prophylactic rule. It goes beyond the core of the actual Fifth Amendment constitutional right. And so there's no, you can't say that any constitutional right was violated by the officer just asking you questions without giving you Miranda warnings first. And second, in any event, the police officer isn't the proximate cause of any injury that happens here, because the prosecutor at the criminal trial and the judge at the criminal trial are the ones that make the decision to move the evidence, move the statement into evidence, and then to admit the evidence at the end of the day. And so if there's any suit here, it can't lie against the police officer because the police officer isn't the proximate cause of the injury that was suffered. The United States filed an amicus brief in support of the petitioner, and the SLLC has also filed an amicus brief in support that not only agrees with the petitioner's legal position, but also lays out sort of the potential impact that this could have on local governments, on municipalities, from the additional burden of Section 1983 litigation related to these kinds of cases. I mean, when you think about it, police officers are encountering people, you know, tens of thousands of times a day across the country. Not all of those result in statements that are ultimately introduced in a criminal trial, but for practically everyone that is, you can imagine a Miranda question coming up, and so you can imagine the spike in litigation that upholding the Ninth Circuit's decision would threaten. The case hasn't been argued yet. Argument is set for April 20th. But I think it's fair to say already at this point that, you know, if I were the one that were representing the petitioner, I would feel pretty good about the way things are trending for a couple of reasons. First of all, there wasn't really a huge need for the court to take this case if it were going to affirm the Ninth Circuit's decision. So the fact that there were 4 justices that were willing to grant certiorari is already a pretty good hint that there are at least some justices that are uncomfortable with the decision that the Ninth Circuit made. And then second, I think it's also worth noting that, you know, there are a good number of justices on the court who are fairly uncomfortable with rights that aren't closely tied to the constitutional text. And Miranda certainly falls in that category. And so I think there are a fair number of justices who won't want to expand the Miranda right further, the Miranda rule further, by providing a cause of action under Section 1983 for damages against local governments and municipalities as a further way to enforce that right. But we'll get a decision by the end of June. Well, we'll get our first clues from the argument on April 20th as to how the court's looking at the case, and then we'll get a decision by the end of June. The last set of cases that I'll be discussing are the abortion cases that have been in front of the court this term, and in particular, the one from Mississippi, which is the Dobbs versus Jackson Women's Health Organization, and the Texas case, Whole Women's Health versus Jackson. So to start with the Mississippi case, the petition in this case, the cert petition, was actually filed back in June 2020, and then the court sort of rescheduled it over and over, and then relisted it over and over, and only finally actually got around to granting the petition in May of 2021. The case there arises from a Mississippi law that was enacted sort of specifically to create a challenge for Roe versus Wade, in which the Mississippi law said that it would prohibit all abortions before, that occur after the 15th week of pregnancy, except for cases in which the mother's life is in danger or cases of severe fetal abnormality. Now, that 15-week mark that Mississippi chose is about 8 to 9 weeks earlier than the viability line, which is at about 23 to 24 weeks, which is what the Supreme Court pointed to in Casey and Roe and said that a state can't prohibit abortions before the fetus is viable. So the Mississippi law aims about 8 to 9 weeks before the point of viability. And so I think everybody concedes that it is fundamentally inconsistent with the line that was drawn in Roe and Casey. So the Supreme Court grants certiorari in that case in May 2021. And 2 days later, Texas essentially says, hold my beer and watch while I try this. And they enact a law that prohibits abortions after 6 weeks of pregnancy. So another 9 weeks earlier, even than the Mississippi ban, at a point where in many cases, the woman doesn't even actually know that she's pregnant. And then Texas also throws a twist into its law and says, this law can't be enforced by any state officials. It can only be enforced by private parties bringing suit, and those private parties can then recover a bounty from any person who violates the law. So abortion providers sue to block that law, but they've got a problem because it isn't clear who's a proper defendant. Normally you have a state law that's enforced by state officials, and so you sue those state officials, prevent them from enforcing it, you can get an injunction against those state officials. Here, there weren't, under the terms of the law, no state official could enforce it. So the abortion providers tried to sue a collection of people. They tried to sue a state court judge, a state court clerk, the state attorney general, and some state medical licensing officials on the theory that each of these state officials had some role in the enforcement of the law. The case goes up to the Supreme Court, and the majority of the court holds that, in fact, the only people from that collection of defendants that could be proper state defendants were the Texas medical licensing officials, who in the court's view under Texas law could have a role in revoking abortion providers' medical licenses if the providers violated the terms of the Texas law. The Supreme Court then remanded the Texas case back to the Fifth Circuit, which certified the case to the Texas Supreme Court to find out the Texas Supreme Court's view of whether those medical licensing officials had any role in enforcing the Texas law. And on March 11th, just this past week, the Texas Supreme Court answered that question and said no, that the Texas medical licensing officials don't have any role in enforcing the law. So that suit at this point appears to be dead. It appears that the abortion providers no longer have a way to continue suing Texas state officials in federal court in order to obtain a determination of the constitutionality of the Texas law. Instead, they're going to have to wait either until they are directly sued and they can defend against that suit in state court, or there are a variety of other ways that people have suggested for potentially challenging the law, but none of them have gotten very far to this point. So at this point, abortion providers are generally not providing abortions after the 6th week in Texas because they're concerned that if they do, they'll then be sued and will have to pay this bounty to a private individual. Plus, by the way, the Texas law also provides that the abortion provider has to pay the plaintiff's legal fees as well. And so there's a significant risk of liability. Now, normally you would say, well, look, but the abortion providers really don't have to be worried because Roe versus Wade says you have a federal right to obtain an abortion before viability. But that, of course, brings us back to the Dobbs case, which is in front of the court now, the Mississippi case. That case is in front of the court on the merits and was argued in December. And I think it's fair to say that it did not go terribly well for the abortion providers at argument. Not to say that counsel didn't do a good job. I think the counsel on both sides did an excellent job of answering the court's questions. But I think it was fairly clear from that argument that there are a significant number of justices who have real qualms about whether the Roe versus Wade and Casey's line of viability should remain good law. So I think, just kind of tallying up votes, people have known for a long time, and their questions at oral argument reinforced that both Justice Thomas and Justice Alito don't look favorably on Roe and Casey. I think Justice Kavanaugh's questions at the oral argument likewise suggested that he didn't really see the constitutional foundation for Roe and Casey. Now, may just be those were the questions that he wanted to ask at oral argument, but those are the clues that we have. And from those questions that he did ask, I think 3 separate times he came back to asking the attorneys for both sides sort of why shouldn't the court just get out of this area completely and leave it to the states. Then, you look at the questions from Justice Gorsuch and Justice Barrett. Both of those, I think it's fair to say, had more difficult questions for the Abortion Providers Council than for the state's council. Justice Gorsuch asked several different attorneys, so if we determine that the viability line isn't workable, is there any other line that would save it? Which at least suggested to me that he thought there really was no workable line here. Justice Barrett asked a couple of times about safe haven laws and whether those really removed at least the burden of parenting an unwanted child, kind of suggesting that Roe and Casey were wrong to think that women would be forced to actually raise a child they didn't want. And so he's focused more on the burden of actually bearing the child to term. The Chief Justice then asked questions that suggested that maybe the 15-week line that Mississippi had chosen here was okay, but that other restrictions on abortion might not be. And so he tried to frame the case in his questions a bit more narrowly as a choice between viability and 15 weeks, still maybe suggesting that he would be open to overruling Roe and Casey, but that he didn't want to go so far as to suggest that it was kind of fair game across the board, that states could enact any abortion restrictions that they wanted. And finally, of course, the 3 liberal justices, Breyer, Sotomayor, and Kagan, all made quite clear that they thought that Roe and Casey should be affirmed and that the Mississippi law should be struck down. So I think at the end of the day, it's really going to come down to the question of whether there are 5 justices in the conservative majority that are willing to sort of really take a wide view of the state's ability to regulate in this area and to try and kind of pull the court out, or whether instead maybe the chief is able to find a more consensus approach that maybe steps back from Roe and Casey a bit, but that still leaves some room at least for a concept of an individual right, even if it allows for some more permissive state, or so I should say stricter state regulations on that right than Roe and Casey themselves would permit. And that concludes the things that I was planning to say about those cases.
Thank you, Harker. So before we turn over to Morgan to discuss her cases, Morgan and Michael, do you have anything you'd like to add to what Harker talked about?
I think you could do a whole session on some of those, but nothing from me right now.
So I think Michael is still muted. Harker, Morgan, why don't you begin with your cases?
Sure. So thanks again, everyone, for having me. We'll kick it off with Shurtleff against Boston, which is the flag case. And you can see that the photo that I've included here, all of this fuss is about those 3 flag poles you'll see in the right side of the picture. And that's outside Boston City Hall, where there are 3 flags that fly, usually the American flag, the Massachusetts flag, and the Boston flag. But sometimes Boston grants requests to swap out its flag for the flag of a private group. Boston, I think, uniquely has said yes, and has said yes a lot to that over the last decade or so. I think it's something like 284 times it has swapped in a private flag for the Boston flag. And so where this case really came to head was when Camp Constitution applied to fly its flag on Constitution Day. Its flag is white. It has a blue square in the upper left corner, kind of like the American flag. And in that square is a red cross. And city officials said no. This seems to be the first no to a request. And they seem to do so based on the idea that there might have been an establishment clause issue in flying that flag. So Camp Constitution sued, alleging a violation of the First Amendment. And by the time the case got to the Supreme Court, the question really was, is this flagpole outside City Hall government speech or is it a public forum? If it's government speech, then Boston has a lot more flexibility about what it can do, right? The government can tell us to eat our vegetables and doesn't have to say, we should also eat cupcakes. It can tell us to recycle and doesn't have to say, we're actually anti-recycling as well. So it can discriminate based on content and viewpoint. But if it opens up some portion of government property to a public forum, then it's private speakers who are speaking, and then the government can't have that same sort of discrimination. So that's really why the whole case turns on, is this the government talking, or are these individuals, private groups talking? So the case was argued on January 18th, and it's sort of a law school dream, many of the hypotheticals that came up, but you could sort of see the issues that seemed most relevant on both sides. On the one hand, Boston got a lot of questions about, isn't this whole decision based on a misunderstanding of the Establishment Clause? You thought, no, you couldn't allow a private group to fly its flag because it had a cross. But if the government is opening up government property to groups, it's not an Establishment Clause issue to allow religious groups as well. And so weren't you, Boston, kind of basing this whole decision on a constitutional error? And then you got questions on the other side of Camp Constitution that said, if this is private speech and you can't discriminate, are we letting, you have to let this a flag with a swastika, the KKK flag, the Al-Qaeda flag, a Taliban flag, a Yankees flag. Those were all the sorts of hypotheticals that came up in that direction. And I think given, as hard as it is to read the tea leaves, given those two types of threads at argument, it seems most likely to me that this is really going to be a ticket good for one day only, that the court's going to say, look, Boston's policy here made this a public forum. It granted private flags permission to fly their flag 284 times. It never denied before this case. It never looked at what the flags looked like. It had a written policy that maybe called these flagpoles a public forum. It did a lot of things that made this look different from the ordinary case where there are flagpoles outside a city government. And but we all sort of know what's going to happen then, right? Boston's just going to change its policy and make clear that it really is government speech. And so, I think at the end of the day, if that's the way it ends up going, it's probably not going to be that meaningful of a case and have as much of an impact on other government groups and other government actions. And on that point, I just want to give a brief shout out to you all, as much as it's a little bit brown-nosing the group I'm speaking to right now, but I do think that the SLLC brief on this, the brief on behalf of local government organizations, was a really useful example of what you can do with an amicus brief by making an argument that doesn't directly track the arguments the parties are making. And in this case, by saying look, we support Boston, but what Boston does is not really what most of us do, right? Most of us are flying fewer third-party flags. When we're doing it, it's really the government speaking. We are endorsing the message of the POW flag or the pride flag, that sort of thing. And so whatever you do, court, don't say that all of our policies are also public forums. And I think that that's, if I had to guess, that type of argument is going to have a lot of sway here, and the court may do something to say, okay, Boston, this is one thing, but what local governments do in the ordinary course, well, that's another thing. So I kudos to you all on that one. So the next case that I want to talk about that Michael briefly mentioned is Berger against the North Carolina State Conference of the NAACP. So this is a case in 2018, North Carolina passed a photo ID law, although I note that, in the grand scheme of these election laws, it's on the permissive side for photo ID. It was pretty immediately challenged as disproportionately harming minorities under Section 2 of the Voting Rights Act and the Equal Protection Clause of the Constitution. And the state's Democratic Attorney General is defending that voter ID law in court. But the Republican president of the state Senate and the Republican speaker of the state House wanted to intervene as parties. Under North Carolina law, both the House Speaker and the Senate President can be agents of the state. I'll throw an asterisk here. There's some dispute about exactly what circumstances, but they can, to some degree, be agents of the state in court. That's not true in every state. And simply put, they don't really like how the Attorney General is defending the law. I think they think that he's sort of rolling over a little bit. I'm not sure they would say he's exactly colluding with the plaintiff, but I think that they think the Attorney General doesn't have his heart in the defense of this law. He's focusing on the administration of elections instead of defending its permissibility and constitutionality. And so they want to be parties too, not just the state election board represented by the Attorney General. Argument in that case will be held on Monday. And I think it's pretty interesting, again, as Michael mentioned, that this is capping off what has been an unusually significant intervention term. This is the third case dealing with intervention. We have the Cameron case, which dealt with, can one state actor intervene to defend a state law when another state actor has stopped defending? We have the Arizona case Michael talked about, can states intervene to defend when the United States has stopped defending? And in this case, it's can one state actor intervene when another state actor is still defending? So we've got all these sort of slightly different angles here. But I do think that there are a couple themes that come up in these intervention cases. And I would, for those of you who are going to be listening to argument next week, I'd keep an ear out for those. The first is, are we meddling with states or are we respecting them? So there was a decision in 2019, Virginia House of Delegates against Bethune-Hill, which I had the privilege of arguing on behalf of the United States in that case. And the question there was a particular election law issue, but part of the analysis on the standing of a state legislature there was, who is a state authorizing to be its agent? And so after that decision, and I think a little bit before, states have really been thinking about who its agent is. And I think the Supreme Court really wants to give respect to states' choices on who can represent it in court. But by the same token, I don't think it really wants to get bound up in intramural fights about, is the legislature versus the Attorney General really representing the core of the state's interests here? And I think that that's going to be a bit of a tension here, that it wants to respect a state's choice to say, okay, we have this entity and this entity as our agents, but it also doesn't want to feel like it's caught in the middle between those two agents. The second thing that I'd keep an eye out for argument, and that comes up over and over again in these recent cases, involves kind of general principles versus the risk of gamesmanship. And I think if you take kind of traditional intervention law, there really is a high standard for intervention of right when somebody else is already there purporting to represent that particular interest or party. And so that's going to weigh on the one side. And on the other side, there's a little bit of this sense of, well, the Supreme Court doesn't want to bless the idea that maybe there's this kind of collusion going on, or someone isn't really giving a full-throated defense of state law. In many ways, similar to some of the concerns that seem to animate the court in Cameron. And so there's going to be a bit of a tension there as well. How much do we just apply ordinary legal rules versus how much do we take into account what we feel like is this sort of realpolitik of potential gamesmanship. And on that, I think there are some clues from the recent decision in Cameron that just came down, I think last week. The one line that really stuck out to me from that line is, I'll quote it to you, respect for state sovereignty must also take into account the authority of a state to structure its executive branch in a way that empowers multiple officials to defend its sovereign interests in federal court. So I read that and thought, I imagine the legislators are going to wave that around and say, look, you have to respect that our state empowers multiple officials. And I think, the other side is going to say, you were talking about the executive branch. The executive branch is historically the one defending in court. And so I think you're going to see an argument, some importance from Cameron, and each side trying to draw some lessons there. The next case and the last case on our docket here today is certainly not the least. This is Biden against Texas, also known as the MPP case, also known as the Remain in Mexico case. I could talk for probably 20 minutes about the procedural history of this one, but I will try to give it to you in a very quick nutshell. There is a statute, 8 U.S.C. 1225, that says when someone arrives at the border and seeks admission, that person should be detained pending removal proceedings, or removal proceedings really encompass asylum proceedings as well. And so there are two exceptions to that general detention rule. One is that the Secretary of DHS has the discretion to release someone on parole into the United States. And two is a non-citizen can be returned to the country from which she arrived by land, so Mexico or Canada, to wait for, again, what's generally an asylum hearing. And so the issue is that it is undisputed that DHS cannot come even close to detaining everyone, as the statute seems to contemplate. I pulled that the SG's office filed its brief a couple days ago, that the most updated facts they gave were in 2021. The nationwide detention capacity was about 34,000, and DHS processed more than 670,000 applicants at the southwest border alone. And that's a big dip from pre-COVID times, where we're talking, about 1 million. So orders of magnitude more people than detention capacity. So what do you do in those circumstances? Well, in January 2019, the Trump administration started using the second option I mentioned, which is this migrant protection protocols or return to Mexico policy, and said, what you do is you make people wait outside the United States, as Congress allowed but didn't mandate. There was immediate litigation over that policy. It ultimately went into place until January 20th, 2021, when the Biden administration immediately suspended it in a couple sentence order, and then formally terminated the policy a few months later. Texas and Missouri sued to reinstate the policy. They won in the district court, and a stay was denied. And so effectively, the Biden administration was forced to restart this Remain in Mexico policy. In October, the DHS secretary issued a new decision that terminated the policy, and this time gave a really full explanation. I think it was about 39 pages. But the Fifth Circuit nevertheless affirmed the district court on two different grounds that we'll talk about in a few moments. The Supreme Court granted cert, issued an expedited briefing schedule, and has set the argument for April 26th. So the question here is really twofold. There's a statutory question. Does the statute require DHS to continue operating the MPP program if it cannot detain everyone? And there's an APA question, which is whether that second really full decision by DHS has separate legal effect and can satisfy the APA's requirements of reasoned decision-making. So look, those questions are big and interesting on their own, even if it's just this specific context. It obviously has huge repercussions for immigration proceedings. But I also think that they have pretty widespread consequences depending on how the court's reasoning ultimately looks. So to take the first one, yes, this might just be an answer about 1225. Does a shall become a may? If the thing that you shall do can only be done in the way that you may do it. There's sort of statutory questions there that are certainly interesting. But I think the bigger question is the court going to say things about executive power? Is the court going to talk about when the executive has enforcement decision-making, when it has discretionary power to say, look, this whole class doesn't make sense for a class of enforcement. This whole class makes sense for parole, or this whole class makes sense for non-enforcement, that could have implications for things outside just this statute and just immigration, right? You can imagine things like drug laws that the executive branch might decide, not to enforce certain amounts of drugs. You can imagine other immigration capacities like the deferred action for childhood arrivals, deferred action for parents of Americans, policies where there's sort of a class-wide non-enforcement decision, and how much of this discretionary authority does the executive branch have? There's an opportunity for the court to say something pretty broad there. Also potentially important, though perhaps it takes a little more explanation to get there, is the administrative policy side of things. So for those who picked up on my reference to the DACA and DAPA cases, the Supreme Court in DHS against Regents 2 terms ago really said, oh, look, if you have sort of an initial decision, an initial administrative decision that doesn't satisfy the ordinary requirements, we think of sufficient reasoned decision-making, adequate explanation, and the like, you can do two things. One, you can give a fuller explanation of the original reasoning, or two, you can make a new decision. And so the Regents case involved the first option, and the court ended up saying there, look, you tried to give a fuller explanation of your original reasoning, but it wasn't sufficiently related. It really has to be an elaboration and not a post hoc rationalization. And so it ratcheted up what an agency needs to do to comply with option 1. And this case is option 2, right? Here, the states are saying, okay, you tried to make a new decision, but it can't be a foreordained conclusion. You can't just take your conclusion from time 1, come up with a bunch of reasons at time 2 to justify it and say, this was a new decision. You need to really have an open mind. And so they're trying to ratchet up option 2. And I think that there will be a pretty significant result for review of administrative action, particularly administrative action that isn't initially as full as it might otherwise be. If you have option 1 ratcheted up in Regents and potentially option 2 ratcheted up here, that would leave a pretty fine needle for the government to thread if it does an initial kind of bad job of explaining a policy change and it wants to take a second run at it. All right, thanks, Lisa. I'll kick it back to you.
Thank you, Morgan. So Harker or Michael, before we take any questions, let me know if there's anything you want to add to Morgan's cases. But before you do that, I just want to let the audience know, if you want to ask a question, you can type it in the chat box.
So Lisa, thank you. I really learned a lot from Morgan's presentation, as always. And what it brings up to me is a little bit of a cross-cutting theme in these cases, which is how are the court's doctrines going to balance its appreciation of its own power, Congress's power, and the executive branch's power. So in the Remain in Mexico case, there's a backdrop of foreign relations authority that the executive has to manage affairs with Mexico. And one of its arguments earlier was, basically the Fifth Circuit's making us negotiate something with Mexico we don't really want to do. And that's an extraordinary assertion of judicial power. There are a lot of other cases that implicate those balances as well. The OSHA case that I mentioned earlier, and there's an emergency docket case, shadow docket case right now about Navy SEALs and whether a court can order the Navy to deploy Navy SEALs who refuse to get vaccinated on religious grounds. And the government is saying, look, we don't agree with the RFRA ruling, the religious ruling underneath this, but even more fundamentally, you can't have courts ordering the military to deploy people, particularly special forces, on missions where they have to work closely with other people and where the failure to get vaccinated can increase the possibility of disease and spreading the disease. The court has that kind of question before it right now. The major questions doctrine is similarly like, well, what is going to happen? Congress often can't get its act together to speak very clearly. And if courts are going to use this gloss of a major questions doctrine to truncate agency authority, then in effect, they are transferring some very important decisions to themselves. That could be the case in the EPA litigation itself. So really, when you step back from all of these things, I think this also is relevant to some of the points that Harker talked about in abortion litigation and who can get sued. The court is really, poised to significantly expand its own authority in a variety of areas by imposing constraining doctrines on other branches of government.
I mean, I won't even try to do a better job of tying up loose ends than Michael just did. I think that really does a great job of sort of pointing out the ways in which a lot of these cases are connected to each other. The only one other point that I'll add on the Biden versus Texas case is to note that I do think this is a case that will be frustrating for a number of the justices, because I think there's going to be a number of the justices that just want to look at the text of the statute and say, look, the statute says shall detain, shall means shall, and so the federal government has to detain everybody. But that just runs head on into kind of the practical reality that the government just can't do it. Congress hasn't provided the funding and the government doesn't have the resources devoted to the question of how to actually detain everybody if that's what the statute requires. So I think there is going to be that kind of a conflict between plain statutory text and just the pragmatic reality of the world that we live in and what Congress has been willing to fund.
So we don't have any questions in the chat, but we do have time for just one question. So I'm going to ask this of Morgan. The MPP case, the court accepted, I think, in February and scheduled oral argument for April. And so the consequence of this is that it means there was shortened briefing. So in theory, the court could have just said, why don't we hear this case next term? And why do you think the court insisted, at the expense of those who have to do the briefing, on a more a short deadline? Why do you think the court insisted on hearing this case this term?
So let me give you the specific answer and the general answer both pretty quickly. The specific answer is one that I think Michael already alluded to, right? That the United States said, this is a case that has significant diplomatic implications, and we are engaged in sort of international negotiations about this, and the uncertainty is causing international friction. We need an answer faster. When you get a request like that from the SG's office and the cost is shaving a couple weeks off of briefing, I tend to think something like that is going to get granted. So I think that's your specific answer. The general answer, and it's pretty interesting to note, I think that the court's been doing a little more experimentation about how to handle these various cases, all of which seem to be on a short fuse. It's done some on really fast briefing, like in the Texas abortion case, and as well with the vaccine cases. It's done some like this on sort of a more traditional expedited schedule, if there's such a thing. And then, of course, it's done a variety of things on the so-called shadow docket or its emergency docket. And so I think this term, more than others that I've seen, it seems like the court's kind of being willing to engage in a little bit of experimentation to see what's the right balance between getting the full briefing, the full argument, and turning around some of these cases that really do have a lot of urgency to them.
So Morgan, when I asked you that question, it was a sincere question. I really didn't know the answer. I didn't read the SG's brief and realize that they asked for that. But when I had read the briefs in the case, the briefs before, or the other briefs, it had never occurred to me, or I'd never thought about what the negotiation must have been like between the United States and Mexico when we told Mexico, these people aren't coming to the United States. They're staying with you. And I thought, oh, to have been a fly on the wall in those conversations. It had just the diplomatic angle had never occurred to me, even though it's perhaps the most obvious one in terms of the, like the scope of sort of trying to solve this problem of being told as another country, like you're going to keep all these people and make it work.
And I mean, I think the diplomatic angle is maybe even more serious when we're telling them you're going to keep all those people. Oh, wait, you're not going to do it anymore. Actually, the court told us you need to start doing it again. Actually, we'll come back to you on an answer soon.
And now we don't want to do it anymore. I mean, imagine Mexico. Okay.
I still have left the SG's office less than a year ago, so I may still have some great sympathies with them on wanting an answer in cases like this.
So the other thing that I couldn't help thinking about was when I listened to the Boston argument, I was marking off questions to how soon the justices asked specifically about the KKK flag. It took 3 questions. And now think about it, it would have been the Russian flag, right? So I mean, it's kind of funny how things change and what's on our minds and what occurs to us when it occurs to us. So rather than requiring everyone to go off mute and sing happy birthday to me, I am going to end the webinar because we are at 2:15. I think all the speakers knew they had to talk a little bit longer so as to avoid that. I want to thank Michael, Harker, and Morgan for your time and information. It was a fantastic webinar. One of the best I feel like we've done it in a while. So for the audience members, keep your eyes peeled for the SLLC review webinar. It's always the most widely attended event. I haven't started planning it yet, but it will be at the in the mid to end of July. So with that, thanks to everyone for attending and have a safe, healthy, and wonderful day.
Thanks, Lisa.
Thanks, Lisa.